a recording in progress. Here we go.
Yes,
We're now
we
live. Yeah, we're live now. Good morning. This is the New York City Board of Standards and Appeals review session for January 11th, 2023. There is no public testimony during review session.
Okay. Do you want to read out the case?
Oh, sorry. Yikes. Sorry. The case we're discussing is special hearing 2017-147A and 2018-183A, 71-12 Main Street, Queens. This is a remand for the motion to review the decision with respect to zoning sections 3322 and 33-293.
And board, I would just like to make a very general statement. In accordance with the court's order on the remand, the court stated, and I'm quoting from the language of the decision, on remand, BSA should adequately address the issue of compliance with 33-293 consistent with this decision. Thank you.
Thank you. So as mentioned, this case was remanded by the court on the grounds of substantial evidence with respect to the board's determination on zoning resolution sections 33-22 and 33-293. Substantial evidence grounds, in essence, means that the board did not provide sufficient justification in the underlying determination with respect to that issue. To the extent the board determines that its underlying determination on this discrete issue shall be upheld, the board shall provide further analysis and justification for this position. The subject site is an interior lot located in an R4 zoning district with a C12 commercial overlay abutting an R4A residential district on the northern side lot line. A 10-foot wide open area is provided at the subject site, coincident with the right-of-way easement located along the northern side of the subject's lot line. This open area along the northern lot line is also a required side yard pursuant to zoning resolution section 33-293. Specifically, zoning resolution section 33-293 refers to the required yards along district boundary coincident with side lot line of a zoning lot in a commercial district. Pursuant to zoning resolution section 33-293, along the northern side lot line of the subject zoning lot, which coincides with rear lot line of the zoning lot in an adjoining residential district, an open area at curb level of at least 8 foot high shall be 8 foot width, shall be provided along such boundary within the commercial district. Appellant states that the side yard is not at the curb level, it is below curb level. So these are my statements. Required yards pursuant to zoning resolution section 33-293 is a defined term, while the open area within the required yard along the subject side lot line is not a defined term. Pursuant to zoning resolution section 33-293, the open area shall be located in the yard. The level of yard is pursuant to section zoning resolution 33-22, which states that the level of a yard shall not be higher than the curb level. However, this section shall not be construed to require that natural grade level be disturbed in order to comply with this requirement. Thus, the level of the open area on a yard is determined by the level of yards. This is also consistent with the way it is applied to zoning resolution section 33-291, one of the 3 special provisions applied along district boundaries. Pursuant to ZR 33-291, the open area alongside lot line shall not be higher than curb level. The only difference is zoning resolution section 33-292, which allows open space to be located no higher than 23 foot above curb at the rear yard, because pursuant to permitted obstruction provision of zoning resolution 33-23, up to a height of 23 foot above curb level, any building or a portion of a building is permitted in the rear yard. In such case, the rear yard can be located above the permitted obstruction and thus the open area at a level not higher than 23 foot above curb level. But in all three provisions, the intent is to set a comparable limit, not a specific level limit for the open area, as it would result in an absurd and an impossible outcome. Please note that even pursuant to zoning resolution section 43-301, which is side lot coincident with side yard, and 43-303 sections of zoning resolution, which are applicable to zoning lots in manufacturing districts, the required yards along residential district boundary coincident with side lot lines of zoning lot in a manufacturing district, the open area shall be no higher than curb level. The provisions of even these three sections also do not set a specific limit. As evident, there is a consistency in the way the drafters of the zoning resolution framed the yard, its level, and open area. Per CP 15820 CPC report regarding the 1961 zoning resolution, the purpose of the 1961 zoning resolution was to establish criteria that would ensure light, air, open space, and would improve the industrial standards, and also for maximum compatibility and mutual protection of uses. The requirement of yard, its level, and open area along district boundary abutting residential use establishes that criteria. So based on this, I would say DOB applied its discretion in interpreting the regulations regarding the subject site, and the existing site configuration is well articulated in appellant's submission of January 4th, 2023, page 2, last paragraph, which states, any solution of raising the easement or / side yard at curb level is not to be entertained, and any solution to address it would discreetly impact the building's exit discharge requirement and decisions already made. You either have it at the curb level and ignore a required exit discharge provision and completely disregard the point that all homeowners need access to their garage as defined by the easement from 1941. So based on my assessment of the zoning resolution and how the zoning resolution was drafted and the consistency of the regulations that is there in the zoning resolution, I think the underlying determination that the board had made regarding the zoning resolution sections applicability of 33-293 and 33-22 should be upheld. Vice Chair Shibata.
Thank you, Chair. I agree with the statements that you made entirely. I believe that our findings with regard to ZR 3322 and ZR 33-293 should be upheld. And I further want to thank the Todd Dale for his January 4th and January 5th brief, which further delineate my position. I have no further statements.
Okay, thank you. Commissioner Otley Brown.
I have no additional comments.
Okay. Commissioner Shetta.
Thank you, Chair. I want to start with saying that I totally agree with the statements you made and with the conclusion you reached. I would like to add some explanations from an engineering perspective to why the claim that because of the area provided, the open area provided is lower than the curb level, that should be considered by the board as it doesn't satisfy the requirements of section 33-293, and how this doesn't make sense, how this claim does not make sense with from the engineering perspective. If when to look at the requirement of section 33-293 as it requires the open area to be at a fixed elevation, meaning that to be at a certain grade and doesn't change. I look at this as an absurd understanding to the zoning resolution section because of two things. Number one, in like most of the sites, the majority of the sites, there is no such a fixed curb level over the entire boundary of a property. Usually, like this is like the norm, that curb level varies from location to location. So if one want to make the open area at a given curb level, a fixed number that stands to a curb level, and the curb level is changing, then this is a dilemma here. And that dilemma needs someone to look into the intent of the zoning text, not just the plain text of that zoning regulation. So this is point one. The second point is, if from the engineering perspective, if you want to make that open area at a given grade, not changing, that may cause engineering issues. The least of them is a water ponding. If stormwater comes and there is no change in grades, and that like very level area receives any stormwater, that means that this water is not discharging anywhere. So these are two engineering points that support the notion that area doesn't be strictly at a fixed elevation. That the next point is, could this area be higher than the curb level? I believe a quick look at section 33-22, where it talks about level of yards, would lead us, and also section 33-291 and 92 would lead us to the understanding that the legislator intended to limit the elevation of that open area not to be higher than a given elevation. So that the only lift option to someone with a site like ours, where the curb level is changing, is whether to put this area as a curb level in case of the curb level is a fixed number, or to make it lower, which I believe is the much better solution than even to put this area at a curb level. The reason for that, it's much better from the open air and light for the adjacent residential property. That's why I'm in support of the decision reached by the board previously, and I still believe that we should uphold this position. Thank you.
Hi, I'd just like to clarify Commissioner Sheta's comments. So is it that you're saying that 33-293, from a zoning intention and an engineering perspective, further the intention is that the curb and the open area not be higher than curb level, but it's permissible to be at or lower than curb level?
The open area cannot be higher than the curb level because of the engineering reasons I presented, and it's better from an engineering perspective and from the legislative intent perspective that this area be lower than the curb level.
Thank you.
Okay. Commissioner Yoon?
Thank you, Chair. I agree with you, and I don't have anything further to add.
Okay.
Okay, since there are no more discussions, this concludes the public review session. We can now commence with the public hearing. Okay, this is the Board of Standards and Appeals special hearing for January 11th, 2023. The item that we were discussing is the remand on calendar number 2017-147A and 2018-183A, 71-12 Main Street, Queens. Parties
We
wish
have
to
Mr.
join in?
Rachmanov and Mr. Vitale for the appellant. We have Mr. Dale present on behalf of the property owner. There is also a member in the waiting room by the name of Leonid Yakubov. Could someone identify if that is part of anyone's team or just an observer?
Hi, this is Todd. Mr. Yakubov is actually the property owner. He's just here to observe.
Yeah.
Okay, so it's, Mr. Dale, is it okay to keep him as an attendee, or would you like him present as a panelist?
I think attendee is fine at this point.
Thank you.
Okay, so we can have Mr. Rachmaninoff start. This is an appeals case, so I don't believe we have to share. They're not being sworn in.
Pardon, this is not an appeals case. This is a remand.
Sorry, I
They
apologize.
do not need to be sworn in, but please do
Right.
identify your name and affiliation for the record, and please begin.
Yes, my name is Benny Rachmanov. Can everybody hear me?
Yes,
Yes.
Okay. And with me is my attorney, Edward Vitale. I think he just came out. I don't know why. So in regards to the statements that were said, there's a few issues that are not applied properly. Specifically, section 33-292 do have an at curb level provision, which states in a C8 district, you have to have an at curb level decision. There were two BZ cases, which I presented in my letter, that show that they had to get a variance in order to apply or to, I guess, exempt themselves from that provision. From what I understand, and hopefully, and my attorney will go in more in detail on that, the regards to the at curb level issue is not necessarily an issue that they cannot get away from. The issue is that the whole process is not in this specific application. This specific application was whether permits and whether decisions were done at the moment in proper setting. So at the moment of when the permits and the decisions were made, permits were given in transgression of this ZR, which this ZR has a solution. The solution is going to a variance, applying section 77-50, which clearly indicates exemption by special permit for 33-29. And then the board has every right to create these, whatever interpretations that they would want to in order to give them reasoning for an exemption by special permit. And in addition, specifically with the decision that was made, there was a false description to the Department of Building that the zoning, that the site actually was at curb level, which was not the fact. The site was never at curb level, but the plans and the zoning documents that the DOB presented was showing that was presented by the owners was showing it at curb level. With that being said, at that moment, there was a misrepresentation of plans. At that moment of the permit was not issued in right. This is like any other product or any other provision would require a zoning variance. So just like any other issues, when there's issues of provisions that are not clear or they're not directly presented properly or that might need a special permit, this is one of them. So we came in with not a variance. You understand? That was my biggest issue from the previous hearing. This is not a variance hearing. This hearing is about whether permits, whether decisions made by the DOB Technical Affairs was properly done. We presented many issues. This is one of the major issues that we had. And we realized that this is not at curb level. This is not the forum to do it. We're presenting a fact that a provision does not apply properly. Therefore, a variance special permit should have been presented, just like any other thing, whether it's a sign, whether, for example, on the 77-50 provision, whether it's a window near along district boundaries, which is within 20 feet, if you want to get that exemption, you can create whatever interpretation you want, but you still cannot get an exemption without a special permit. That's what has to be done. This has to be reversed, and they have to follow the special provisions of special permit to give us as the community an ability to present our case in a variance form, which is much more stricter than a self-certification, the process that we are in today. That's my opening statement.
Okay.
Mr. Rachmaninoff, would you like to present more, or would you like to now hand it off to
I would like to defer to Edward, my attorney, so we can take it from there.
Mr. Vitale, please just identify yourself for the record and your affiliation. I just want to let you know, I don't believe we can hear you. It might be a connection issue or you're muted.
No, we still can't hear you.
It appears that he's freezing.
Steve, would you mind please putting the dial-in instructions on the screen? So if Mr. Vitale wants to
Yes.
dial in, he can attend by phone, which would have a much better connection and we'll be able to hear you.
So you can dial in at 646-558-8656. You'll enter the webinar ID number 813-8420-5746 #. Then after that, you will press the pound sign only. *9 to raise your hand. *6 to unmute if you're on the phone in order to speak. Press that. Is he it? No, it's not. Let's see him calling in.
All right, we've admitted a phone number ending in 374. Could you please
Hi.
identify yourself for the record?
This is Edward Vitale. Can you hear me?
Yes, we can hear you.
Okay, let me,
Gonna turn off your, oh,
Yeah.
turn off the YouTube.
hi, I'm sorry. Hi, I do apologize. I'm not really sure what's going on. I've never had an issue before. Can everybody hear me?
Yes.
We can hear you perfectly.
Okay.
Just state your name and your affiliation and please present.
Okay, sure. My name is Edward Vitale. I'm the attorney for Benny Rachmanoff, the applicant in this proceeding.
Please go ahead.
Okay, so very briefly, I was able to hear most of what the board said in the initial proceedings, and I just would like to point out a few things. First, I'd like to clarify 2 or 3 things that I think are very important that were mentioned in the appeal that were not noticed or that were not raised. First, yes, while it was remanded on a basis of substantial evidence, is also arbitrary and capricious. The second thing also, which I also think is even more important, is that the court states 33-293 imposes a stricter requirement as to the curb level. And I think this is a very important fact. While I hear and I think if you just break it down, what the board was trying to say was that it was looking for the intent. And especially, and I do apologize, I don't recall the names, but one board member specifically went into the fact of with regarding to engineering issues. And I do understand what that gentleman was trying to say, what that board member was trying to say, and the rationale. But the rationale there is very different than what the statute says. And as all the board members pointed out who spoke, all these statutes have different requirements, some at curb level, some higher than curb level. And I think it's very insightful here to understand that and to see that, because where it says in the statute specifically at curb level, there was a rationale. Now, maybe there are reasons that at curb level cannot be appropriate for certain circumstances, and a variance would be required for drainage, for certain engineering issues, for other issues. But as we noted, and as the court specifically noted, a stricter requirement under 33-293, the statute reads as the statute reads, and we must apply the statute. It's not an intent here, and I think that's very important, which the board has to keep in mind. If the legislature chose to put a different requirement or a variance, or sorry, the wrong, I don't want to use the word variance, a stricter requirement or a looser requirement or a different requirement or something else, they could have easily placed that in the statute, but they didn't. And I think it's also instructive with Mr. Rachmaninoff's submission that he does set forth various cases where variants were issued. The variances were issued because they did not comply with the statute, and that the variance had to be because it wasn't at curb level. Now, I remember one board member did mention, you know, it's not realistic. All levels are different on a site. No site is perfectly flat, and then I do appreciate that. But I don't think, I think that we have to look at here at the totality of the situation, in the sense that, you know, here the average height is approximately 75 or 76, while the driveway is at 72. So, you know, it's just not at curb level, and the statute is clear, and the Court of Appeal, the Appellate Division was clear that this is a stricter requirement. And just because an intent might be seen, I don't believe that follows. And that's really my position.
Thank you.
Mr. Rachmaninoff, do you have anything that you would like to add?
Yeah, I would like to add a few points here as well. In regards to the statute of 33-293, it's obviously a long district boundary issue, and this isn't a long district boundary property. Now, in the specific thing, it's not that the owners were not notified about this issue. They were notified about this issue, and my biggest concern is if the DOB would have seen it clearly to be under curb level, then they would have said that it would have been approved and not denied, and that's the biggest issue here. And that was what I tried to present in the previous hearings as well in 2019, that the DOB was given false information, that it was not at curb level. So maybe Thomas Fariello at that time would have agreed with me, would have said, like any other plan examiner would have said, denied, get a BSA approval, because that's not our privy to make a decision for. And I know that BSA variances are more stricter. You have to do DOT, you know, you have to see how will it affect the community, how will it affect the block. And that's specifically what we're in now. Now, with the section of 33-293, it's very hard to say what everyone is saying when 33-292 has a double provision. It's a double provision at curb level and at now higher than curb level. Because in C8 districts, it has to be at curb level. And I have to double down on this. You had specific zoning resolution, a specific BSA hearing that I presented that needed to get a variance. That is the procedure of BSA. That was the procedure that was supposed to be taken to give the voice to the community if they wanted a special permit. So I'm just explaining that specific point again, just to clarify everything that we said till now.
Thank you for your testimony. Mr. Vitale, do you have anything else that you would like to add?
No, thank you.
Okay. Thank you both for your testimony. We would now call on Mr. Dale to present. Thank you.
Hi, good morning, everyone. Todd Dale. I'm appearing on behalf of the property owner. I would just briefly state that we appreciate the board's comments during review session and the additional analysis. We believe the comments made address the requirement of the court to provide additional analysis and support for the board's prior decision regarding section 33-293. We would just note that we think it is appropriate to view section 33-293, which sets forth an open area requirement, which is not a defined term, rather than a yard requirement, in light of companion sections 33-291 and 33-292. The only other comment we would just make at this time is that the two cases that were included in Mr. Rachmaninoff's submission, where there were variances applying to 33-292, that both of those applications involved portions of a proposed building being within the open area, which is easily distinguished from the subject site where there is no structure within the open area. And I think that that easily distinguishes those two particular cases. That's all that we would say at this time. And again, we appreciate the board's attention to the matter and look forward to resolution on this, which has been a significant burden on the property owner.
Thank you all for your participation. I would like now to make a motion to close.
Okay. Chairperson Shonda,
Aye.
Vice Chair Shabeta,
Aye.
Commissioner Otley Brown,
Aye.
Commissioner Sheta,
Aye.
Commissioner Yoon.
Aye.
The board's decision on this matter will be scheduled for a later date. Should the board determine that it upholds its decision in the underlying determination on this remand, the board will therefore be required to issue a resolution on the remand dictating such, and will be required to reopen the underlying matter and reissue its revised determination. In the alternative, should the board on this remand make the decision that the underlying determination with respect to 33-293 and 33-292 was not supported by substantial evidence, the board will be issuing a resolution under the remand as to that point, and will be reopening the underlying appeal for further hearings consistent with that determination. Thank you.
I also want to make it. I also want to make sure that this is a close. The record is closed at this time.
Yes, that is correct.
Thank you. Thank you. Thank you all very much, and have a good day.
Thank you.
This concludes the public hearing.
Public
for-
hearing. This concludes the public hearing for June 11th. January 11th, 2023.
Thank you all.